Awesome. Thank you very much.
Thank you.
Please go ahead.
May I proceed?
Yes, you may.
All right. May it please the Court. Attorney Steve Rosenthal for the mother appellant. Your Honor, mother concedes that at the time of trial, she was unfit. Okay? However, we're asking for a remand in this case for two reasons. Number one, this Court must remand the case due to a change in circumstances. The adoption plan approved by the trial judge has been disrupted. The child was in a specially trained, comprehensive foster placement due to the child's significant needs. He was there from September of 2020 to December of 2023. Now, the trial ended in...
Change to a kinship placement. We've got the facts.
Okay.
Why, under adoption of Willow, don't we follow the rule that the party should address the propriety of the judge's orders based on the evidence introduced at trial and not on post-trial events? Why isn't the changed placement something that could be raised at a permanency hearing?
Well, Your Honor, I would refer you to the case of adoption of Zach, 90 Mass Appellate Court, 840 at page 844. In that case, the parents retained standing to appear in the trial court even after a TPR was upheld on appeal, where the remand proceeding was part of the same proceeding to which the parents were already a party. So without addressing Willow directly, I would say that Massachusetts case law supports a remand, but mother she retains a right to, at a very minimum, question the placement of the child in the best interests of the child and her visitation rights to the child.
But in Zach, was the case being remanded for another reason? Or solely because of some post-trial development?
Well, we have a post-trial development in this case as well.
Right, that's what I'm...
The question was solely, yeah.
Oh, okay. My position is that because of this disruption of the placement, mother has rights to question the current placement of the child. It was never examined by the trial judge. This was a placement, well, there's some confusion about whether we're talking about a maternal aunt or a paternal aunt. And this was, whoever this aunt is, she only had one visit with this child throughout the entire course of this case.
This calls into question the best interests?
I'm sorry, could you speak a little closer to the mic?
Yeah, sure, happy to. You're arguing that this calls into question the best interests determination of the trial judge?
Also, it calls into question the calculus that goes into deciding whether mother is entitled to visits with the child. Under the original court order, court did not order any visits and relied on the custodian to grant visitation. So it was within the discretion of somebody who's no longer a part of this case. We don't know much about this new placement's interest in fostering or promoting visitation with the child.
And if you were to file some kind of 60B or analogous motion, would to revisit the issue of post-termination visitation because there's been a change in the custodian, would the trial judge lack power to rule on that? So that's only if we remand?
Well, more than a year has gone by since the judgment issued.
Right, but not everything in 60B is limited to a year.
I would think it would be a 60B6 motion, and there would have to be extraordinary circumstances, and frankly, I don't believe that this would be considered an extraordinary circumstance.
So you think we need to remand, even if only on the question of post-adoption, post-trial visitation, post-termination visitation? Because otherwise the judge won't be able to consider it?
My position is that the case needs to be remanded in order to consider the best interests of the child vis-a-vis mother.
Vis-a-vis when? Post-judgment? is what
It
you're
it would
saying,
be
right?
post-judgment visitation, yes.
No, I mean, what is the time frame in which that issue is going to be examined? I believe you're saying is for developments that have occurred post the judgment rendered in this case, correct?
Yes.
Okay. And are you no longer asking us to evaluate whether or not it was an appropriate aspect of the decision?
Inappropriate what, Your Honor?
Excuse me. Are you no longer asking us to determine whether or not the judge abused, I think it's her discretion it's Loseaton, abused her discretion when she entered the order denying post-visitation at this time? Is that what you're saying?
At that time, it was within the judge's discretion. Now, there's been a change of circumstances. We're dealing with a whole new placement, a whole new person who's going to step in to adopt this child.
Well, the judge did find not only that there was some interest on the part of the then foster care placement to allow visitation, she found some openness to that, but also that there was no real bond to speak of. So even if the custodian, and perhaps the custodian's willingness to allow visitation has changed, why should the judge have to revisit the determination that there wasn't a bond that warranted any kind of order?
Well, the judge seemed to focus on the bond between the child and the foster parent, not so
Well, the
much.
judge found in a couple of places that there was no bond to speak of between the child and the mother.
Well,
And that's what the judge, that was certainly a significant part of the decision on visitation.
I understand that, but in that particular case, the judge overlooked the fact that mother had parented this child for the first 2 years and 9 months of his life, and that visitation went well, and that
So are you saying that?
he showed affection towards his mother.
But was the finding of no bond clearly erroneous?
In the context of having placement or having adoption by the person who was being considered at the time of trial, it was not an abuse of discretion. It would be an abuse of discretion to make the same finding now that there is a relatively new adoptive placement.
But how do we know that? How can we evaluate that? Doesn't it, in other words, why isn't this brought to the trial judge in the first instance? What is the date of the change?
Date of the change was 3 weeks after the trial ended, but several months before the findings of fact issued.
Okay, so why wasn't that brought to the attention of the trial judge then? And certainly would not have been an issue with respect to timing under our rules.
Mother was not made aware of that. In fact, I wasn't made aware of this change until my brother filed the motion to file the supplemental appendix.
Okay.
So at that point in time, I know there was a motion to file to stay appellate proceedings, but that was on a different basis. Did you consider filing a motion to stay appellate proceedings on this basis in order to give the juvenile court the opportunity to address this in the first instance?
Well, again, it seemed like a slim reed to rely upon, Your Honor, because at that
We're
point,
much more reasonable than we appear on the bench, actually, so.
at that point, more than a year had gone by since the judgment had entered. Judgment entered in July of 2024. So we're in late.
Yeah, but if you
Late
didn't know, if you didn't
2025.
know about it, it seems to me that would have been a good basis for going back to the juvenile court.
Maybe even an extraordinary circumstance.
My position is that this would not constitute an extraordinary circumstance that would justify reevaluation of the case. And it's not due to any latches on the part of mother that this
So,
happened.
Back to the question I asked initially, because I fully admit that I'm a bit confused in terms of your position as to what you want us to do with what we have right now in front of us. You do then want us to address whether or not the judge abused her discretion in determining whether or not there should be no post.
Yes,
Termination, visitation.
yes, I'm sorry if I didn't make that
Okay,
clear.
no, I wasn't, I'm sure my question wasn't quite clear, but anyway, now we should look at that. And if we were to say there was no abuse of discretion, then what is your next step?
The next argument is that DCF did not make reasonable efforts to reunify this family. And I addressed that in my brief. We talked about,
Let me actually jump ahead. What if we were to disagree with your arguments in your brief, hypothetically, find that there was no abuse of discretion on any of the points? You're still left now with this new circumstance that you presented to us. If we don't remand, is that never going to be addressed as far as you're concerned?
it seems to me that the only way it could be addressed would be if there were going to be further adoption proceedings. But mother, if her rights have been terminated, she doesn't have the right to oppose those adoption proceedings.
Seems to me there has to be a way to cut through this conundrum, and of course we'll hear from your brothers here shortly.
I would like to get to your first argument about reasonable efforts and failure to follow disability policy. Even if DCF failed to follow its disability policy, why is that something that we should try to figure out for the first time on appeal where it wasn't raised below? I understand that the mother herself may not have, given her disabilities, may not have been in the best position to raise that, but the mother's represented by counsel throughout. Why can't counsel say, hey, DCF, you're not following your disability policy, and therefore you're not making reasonable efforts, and bring an abuse of discretion motion, or the various ways that this can be brought up? So why isn't that waived? And
all right. Mother's counsel did object to the level of reasonable efforts that were being made by DCF at one of the foster care review meetings. And I believe it was at that same meeting that the foster care review determined that DCF wasn't meeting that standard of reasonable efforts.
right,
And to
but
answer,
yeah, I understand that's in the foster care review report. But
and-
my question really is, where did the mother bring it to the attention of the judge to allow the judge either to, give some relief or make some findings that we could review on appeal? How can we unscramble this on appeal where it wasn't litigated?
well, Your Honor, you,
And all the ordinary reasons why we have a waiver rule.
because the dispute here was not a dispute raised, it may not have been a dispute raised by mother, except for her attorney at one of the foster care review meetings, but there were 3 foster care review meetings at which 9 different panel members, 3 for each of the foster care reviews, said, you need to consult with DCF's disability experts,
Right.
domestic
But the
violence
fact-
experts, and incorporate those
Yeah, and your
recommendations
view is
into the
that-
action plan.
And your view is that DCF didn't do that. But
And
still,
I-
how are we supposed to evaluate any of this where it wasn't presented to the trial judge?
Well, Your Honor, I would refer you back to the adoption of Lavar case, which you and I
Yep.
talked about last spring. And in that case, the opinion stated that there must be some disagreement over whether DCF reasonably could further provide accommodations. Now, what more do you need to show that DCF could have reasonably provided further accommodations than the recommendations of 3 different foster care review panels stating this is what you need to do? And then you haven't done it since the last time you were here.
I suppose mother or mother's counsel raising it with DCF is what more you could expect.
And mother's counsel did raise that during the second foster care review. No, there was no abuse of discretion motion filed. I concede that. However, I think that under the Chad case, which is cited in my brief, I'm sure you're familiar with it, and numerous other unpublished cases, there are situations where this court will consider a reasonable efforts argument, even if it wasn't raised in the form of an abuse of discretion motion or something of that nature at trial. In fact, one of the things I wanted to ask for in this case was for this panel to issue a published opinion, because there has never been an opinion published in the Massachusetts Appeals Court Reporter that deals specifically with the impact that DCF's own disability policy has on its obligation to make reasonable efforts.
Maybe one reason for that is because it was never raised below.
And one reason why we address that often in unpublished decisions is it's usually prefaced with, even if it had been raised. And of course, the reason for that is to be sure that the parties know that we've considered it. But thank you very much for your argument.
All
We
right.
appreciate
The rest
it.
of my
These are
briefs.
always
Thank you,
difficult
Your Honor.
cases, and we appreciate it. No further questions. Right? Thank you very much. All right.
Morning, Your Honors. May it please the Court. Matt Burke on behalf of the Department of Children and Families. In this case, the trial court found the mother to be unfit and terminated her parental rights based on extensive findings of fact in the record. First, there was a history of domestic violence between mother and father, with both as both aggressor and victim. That domestic violence began before the child was born and continued throughout his life. The child was present for at least some of those incidents of domestic violence. The trial court found a pattern of the parents engaging in violent conduct and then minimizing or denying that conduct. When offers of counseling services were unsuccessful, the department encouraged the mother to live separate from the father. She declined. Second, the trial court found that the mother's mental health issues impaired her ability to care for the child. There were 2 required psychiatric hospitalizations prior to the transfer of custody to the department, and the only expert who testified at trial found that the mother's disabilities made it unlikely that she could provide minimal care and protection for the child. And third, the child is autistic, and the trial judge found caring for that child required extraordinary attentiveness, which the mother was not able to give. On that basis, the trial judge found the mother to be unfit and found it to be in the best interests of the child for the mother's parental rights to be terminated. The primary issue in the appeal brief from mother deals with the argument there's a lack of reasonable efforts by the department to provide services to address the mental health issues. That issue is not successful for the mother for 2 reasons. One, as the panel has already pointed out, it was not raised below, and our position is it has therefore been waived. And second, even if the court were to consider that argument, the record is clear that the department, in fact, did make reasonable efforts to provide services to address the mental health issues that the mother suffered from. As to waiver, the SJC's decision in Gregory is clear that a lack of services argument must be raised in the trial court. In fact, the SJC says it must be raised prior to the trial on termination. Here, the issue was not raised until appeal. It was raised for the first time in the opening brief from mother. As a result, it is waived. There are comments in the brief about purported gaps in the record regarding the services that were provided, and essentially an invitation to this panel to draw inferences from that negative to the department. We would submit that is not proper here. What should be, since it was not raised below, the only thing we can really draw from that is there was no reason for the department to put in evidence on every service that was offered or every response to the FCR panel's recommendations because the issue was simply not before the trial court in the termination proceedings. Even if, and with respect to the Chad case, the holding there was that inadequate services was a theme that ran throughout the case in the trial court. Here, that is not the theme that ran through the case. The theme that ran through the case in this trial court was the mother's rejection of the department's offer of services. Even if the panel does consider the reasonable efforts argument, it's clear from the record that the department met its obligation here. First, the trial court found that the department offered extensive services to the mother: psychiatric evaluations, medication evaluations, psychotherapy, early intervention services, and other parenting training, parenting skills. In each instance, the mother declined those services. And when they were unsuccessful, the department was unsuccessful with those services, it made a referral to the Department of Disability Services, assigned a social worker to assist the mother to obtain services from that department. Again, the mother declined. It's clear that none of those findings were clearly erroneous. The record here, the family action plans, and other documentation throughout the pendency of this case in the trial court make clear that extensive services were offered. Second, the mother declined to acknowledge that she had mental health issues which impaired her ability to care for the child, and she declined the offers of services that the department made available. And third, this court's decision in Yelena and other decisions finds that the obligation of the department to provide reasonable services is contingent on the parent's obligation to pursue and make use of services. Here, not only did the mother not seek out those services, she affirmatively rejected the services that were offered by the department. And it's clear, not just from the documents, but from mother's own testimony at trial. She acknowledged that services were offered. She declined to accept them. She acknowledged she believed she didn't need them to care for her child.
But was the department offering the right ones? I mean, it seems the mother is taking the position that it wasn't.
Your Honor, in large part, the department and mother never got beyond the assessment stage because mother refused psychological evaluation, she refused medication evaluations. So in large part, the department was not able to identify specific needs because of mother's refusal to participate in the process. Obviously, mother must participate in order for the department and its experts to identify what those needs are. Notwithstanding that, the department, as I said, made numerous efforts. When they were unable, through their own resources, to meet the needs of mother, they made a referral to the Department of Disability Services, assigned a social worker to manage that process, but again, mother declined to participate. So it's clear, whether we view this as a waiver issue or an issue on the merits, that the department did in fact make reasonable efforts to provide those services to the mother.
Can we get back to the visitation issue before you run out of time?
Certainly, Your Honor.
So let me ask you this. Do you agree with Attorney Rosenthal that the only way that he can address that with the trial court is through a 60B6, which, as I think he accurately states, is quite a narrow read?
Your Honor,
Or is there another vehicle with which to get it before the trial judge?
yes, I think there is another vehicle, Your Honor, and that is an ongoing process. It happened during the pendency of the case in the trial court, and it continues to happen now, and that is through permanency hearings under Chapter 119, Section 29B.
Is the mother a party, though? Can she participate once her rights have been terminated?
She cannot, Your Honor. She can petition the trial court to see if the trial court will allow that, but once her rights are terminated, she does not have standing to appear at those hearings. As I said, she can ask the trial judge. But again, here, the issue was not, in terms of terminating her rights, the issue was her fitness to parent the child. The issue was not the existence or absence of preferred alternative options. At the time of the trial, no decision had been made as to adoption. The aunt, who is the current, where the current child currently resides, was found by the trial judge to be an approved resource. The trial judge also found that there was a pending case review meeting to determine and evaluate options here. And so the process will go forward to identify what the appropriate adoption resource is, and that will happen separate and apart from the mother's rights here, which have been terminated, again, based on her unfitness, not based on the availability or identification of a specific alternative placement option. The court correctly found that visitation should be left up to the person with whom the child is residing. The fact that that has changed since trial doesn't change the correctness of the trial judge's decision, and it certainly doesn't make it an abuse of discretion. That issue, again, is being assessed by the trial court on an ongoing basis. It remains the case that no permanent adoption decision has been made pending this appeal. And so the trial judge will assess all of those options, both in terms of the appropriate placement for adoption purposes and any visitation issues through the permanency hearings. And that will happen regardless of the outcome of this appeal. And it should happen without altering the trial judge findings in this case regarding mother's fitness, the best interest of the child of having a placement other than mother, and therefore the department would ask that the court not remand the matter, but rather affirm the trial judge's decision, and we would submit on this argument and the briefs we submitted. Thank you.
Thank you very much.
May it please the court, Eric Beal on behalf of the child. Looking first at the reasonable efforts issue, the child agrees with the department that that issue was waived. And one of the difficulties with not having a trial court record is the standard of review. DCF bears the burden to prove by preponderance of the evidence that there are reasonable efforts. Without a trial court record, it's very difficult, if not impossible, for this court to assess if there was such evidence, and in fact, if therefore the reasonable efforts finding was clearly erroneous, which the child submits that it was not. Even if there was insufficient evidence of reasonable efforts, the best interest of the child still controls, and therefore even a lack of reasonable efforts is not a bar to a court moving forward with a termination of parental rights where the best interest of the child demand it. The child submits that that's the case here. The child would refer the court to, in addition to the cases cited in the child's brief, also Rashida, which is 489 Mass 128, and that's a 2022 decision of the SJC. Looking at the placement issue, this was raised for the first time in the mother's reply brief, and so the child submits that really the issue shouldn't be considered by the court. If the court in its discretion does want to look at that issue, the child's position is that the plan that was approved by the trial court was a plan of adoption, and there was social worker testimony that even if the placements, the current placement and the placement with the maternal aunt fell through, that there would be a recruitment plan. And that was baked into the court's decision on adoption. And where here, there's been a placement change from one pre-adoptive resource to another pre-adoptive resource, that still falls under the plan for adoption that was approved by the court. Moreover, under this court's decision—
Can I ask?
Yes, sir.
Is there any reason in the record to think that the child's new placement is a kinship placement, correct?
Yes, Your Honor.
Is there any reason to think that that placement would not be as open to visitation as the prior foster care placement?
There's not a record of that, Your Honor, but from the child's perspective, the critical issue is with visitation is that the trial court must find that there's a bond and that the visitation is for the child. It's not for the parents. And there was no bond found here that would justify visitation and no other evidence that would justify a finding that the child's best interest demanded visitation with the mother. Those facts are not in evidence on this record. With respect to, I wanted to add that related to the last point in this court's decision, adoption of Caesar, 67 Mass App Court 708, that's a 2006 decision. This court held that a mere change in placement does not by itself require a remand. And moreover, this placement with the maternal aunt was not a surprise. Indeed, on the last day of trial, the trial judge and counsels discussed the scheduling of the permanency hearing on May 21st, 2024. DCF submitted a 29B letter permanency plan that was approved by the court on May 21st. That's an order of the trial court, and I submit the court can take judicial notice of that. And with the court's permission, I would file that with a Rule 16 letter. That court's order adopting the adoption plan and placement with the maternal aunt. And again, that was in May of 2024, just a few months after the end of trial.
That the court approved adoption by the aunt?
Approve the permanency plan for adoption by the maternal aunt. Yes, Your Honor. And finally, related to Justice Sack's question, Chapter 119 does express a statutory legislative preference for kinship placements, and that's Chapter 119, Section 23C, and that the placement with the maternal aunt here is fully in keeping with that statutory purpose. If there are no other questions, I see I'm just about out of time.
No, I see no more questions from the panel. I have none either. Thank you very much for your argument. We appreciate all three of you for being here today and presenting the case to us. Thank you.
Thank you.
Take the case under advisement. Okay, this brings us to the last case we're going to hear this morning, which is Michael Bruno versus Alliance Rental Group, LLC, and another, 2025-0383.
All set? Good afternoon, Justices. Happy to say I get to be the first one to say good afternoon. If it pleases the court, David Travers on behalf of Alliance Rental Group.
I'm just going to ask you to come a little bit closer to the microphone or pull it towards you. Thank you.
Okay. Does this work better?
Yes, it does.
All right. I'd like to approach this in three parts. First would be to address the threshold issue of jurisdiction in this court, which was raised by the parties in their briefs. Then to deal with the trial court's findings and determination on remand with respect to damage caused to Mr. Bruno from the underlying 93A scheme. And then finally, the allocation or lack thereof of post-judgment interest. And to begin with the respect to the jurisdictional issue, I respectfully submit to this panel that both parties have gotten it wrong. In preparing for today's hearing, it occurred to me that both parties are evaluating this from a judgment-by-judgment point of view with respect to the timelines for 59E motions, motion for reconsideration, and filings of notices of appeal. That approach is wrong, and I apologize for wasting this court's time with those arguments in the briefs. The correct approach is to look at when did final judgment enter. Final judgment as defined by Rule 54A is the final adjudication by the trial court. The final judgment here, where these remand orders were broken into three separate parts, the final judgment occurred on February 13th, 2025, when a further judgment was entered with respect to attorney's fees awarded by this court the last time this case was up at the appeals court, which adjudicated the last thread of the disputes between these parties on these claims. The prior two decisions, October 7th and October 16th, when two separate judgments entered, those only partially addressed each portion of this case. In order to have separate and final judgments, which would trigger separate and final timelines for Rule 59E motions, for filing notices of appeal, you have to adjudicate the entire case, or in the alternative, the Superior Court is required to make specific findings as to the basis for having separate
Which
and
it
final
didn't
judgments.
make here, but why wasn't the second judgment, I guess the one in favor of Alliance, the final judgment, because it wrapped up all of the claims and defenses that were then pending in the Superior Court. Yes, a rescript came down from this court about attorney's fees, which subsequently modified the judgment, but wouldn't you agree that as to all claims then pending, the 2nd October judgment was the final one that wrapped everything up, and so triggered an appeal clock, which was subsequently told by the motion to reconsider?
That is, thank you for that. That is the fallback argument of my new point of view, which is that if you look at it the way you've just described, Justice Sachs, then on the 16th, you have the final judgment for the adjudication of the actual claims between the parties. You had one judgment with respect to Bruno's claims, one judgment with respect to Alliance's claims. That second and therefore final judgment of the claims enters October 16th, at which point a timely Rule 59E motion was brought on October 28th. Yes, that's 12 days later, but as explained in the briefs, the 16th was a Saturday, the Monday was a holiday, so it falls within the time standards, the 28th. It was labeled a 59E motion. It addressed both of the issues that are presently before this panel and told the running of the timing for notice of appeal. Once that was resolved, there was a timely notice of appeal recorded within 30 days from the January 29th order. And in particular, I would draw the panel's attention to Mass Rules of Civil Procedure Rule A2C, which specifically says if you have a motion like a Rule 59E motion, and I want to get the language right here, the notice of appeal is due within 30 days from the decision on the last such remaining motion. This is evidence of the concerted policy contained within the various appellate rules to join issues before they are ripe for appeal. You don't take things one by one without very specific findings from the Superior Court, and so everything joined in as of the 29th of January 2025, when the last motion that would toll the filing of a notice of appeal was decided by the Superior Court.
What is your best authority for your new theory?
So the best authority for the new theory exists in the physical rules themselves. For example, Rule 54A that defines a judgment as being the final adjudication of the rights of the parties of the judgment. Mass Rule of Appellate Procedure 4A2C, discussing the notice of appeal runs from the last such remaining motion being decided by the Superior Court. Also, in the Mass Rules of Appellate Procedure 4A1A, a notice of appeal shall be filed within 30 days
Got
of
it.
the
So
judgment.
you're relying strictly on the rules. You're not citing to any other authority or any other case to support that, your new theory?
Not quite. In addition to the rules, there is a case that I think by analogy is instructive. It's a recent case, Justice Sachs, you may remember it. You sat on the panel. It's Alberti v. Alberti, 104 Mass Appeals Court 235, a
Could you slow down there?
2024 case.
Went a little bit too fast for me.
I apologize.
What is the site again, please? What is the site again, please?
104 Mass Appeals Court 235 from
Alberti v.
2024.
Alberti. Thank you.
And that is a case in which it was held that a separate and final judgment was not appropriate where the surviving claims were factually and legally overlapping. And then there, the court pointed out to the parties that you cannot manufacture separate and final judgment. In that case, there had been a summary judgment entered, and one of the parties had dropped the remaining case that hadn't been ruled on while reserving the right to bring it again later. And the court said, no, you can't manufacture finality like that. In the same respect, the Superior Court or the clerk's office can't manufacture finality by issuing judgments in sequence and out of time with each other. The existence of a final judgment only happens when there in fact is a final judgment, which is the adjudication of all of the claims between the parties.
So as your time's running, why don't we move to the 93A issue, your second issue? And let me ask, I have a background question, and that is, with respect to the $900,000, the two lots that were contracted for by Mr. Ivester, was there anything that precluded him from filing an action against Bruno to recover that $900,000 or for specific performance to recover the lots?
Anything that stopped who?
Mr. Ivester.
Mr. Ivester, I can't speak for Mr. Ivester, but no, if he felt he was having his contract breached, he had a right of action. He didn't bring it. The statute of limitations is now told, and the facts are final for all time, which is that there will never be an action for any payment or right to any of that money to Mr. Ivester.
So in support of that argument, you're citing the no injury line of cases. Those are actually under 93A Section 9. This, as I understand, is a 93A Section 11 case, correct?
Yes, business to business.
Okay. Do you have any authority in the 93A Section 11 context to support those claims?
Rhodes v. AIG, 461 Mass. 486, and the Hirschnow v. Enterprise Rent-A-Car.
The Hirschnow's a Section 9 case. It's the consumers renting the car.
It is a consumer, but it's in the context of insurance, and therefore what is a reasonable settlement for an insurance company.
Right, that's Section 9. There's no reasonable settlement offer component to Section 11.
And as I stand here, I don't specifically have a Section 11 case, no.
So I'm trying to understand this argument, and I have two scenarios for you. In scenario A, Bruno pays a judgment of $180,000 for liens that were not inflated. Scenario B, Bruno pays a judgment of $585,000 for liens, $405,000 of which stem from amounts that were, quote, unreasonably, unfairly, and deceptively inflated, end quote. How, in the second scenario, did he not suffer a loss of money?
The other subordinate findings in the decision, including from this court, which is that Mr. Ivester completed the work with Alliance's equipment. Mr. Bruno then was able to sell those improved lots for $450,000 apiece.
Did the court conclude that he concluded everything and under the terms of the contract, or was the judge just saying he finished what he did?
He finished what needed to be finished for the subdivision plan to be approved and the lots to be available for sale, which is what allowed them to actually be marketable and sold as separate housing lots. So the very creation of a marketable asset happened through the use of Alliance's equipment, which enriched Mr. Bruno. That's how we get to the idea that this scheme, as much as it may have unreasonably and inflated the lien, because of the way the mechanics lien statute works, it can't inflate that lien to an amount more than Mr. Bruno expected to pay to get 11 released lots.
But in one case, Bruno has to pay an additional $400,000.
Yes, he does.
So again, how is that not loss of money?
Because he's still paying $317,000 less than he would have for what he received.
But why does Alliance get credit for that? If he owes money or lots, it's owed to Ivester. Why should that reduce be counted against the damage that he suffered because of Alliance's involvement in this scheme that the court found?
Because it's not owed to Ivester. That's the money will never be due to Ivester. So the way the mechanics lien statute would normally play out in a situation like this, where you have a fixed price contract that has a cap, if you have a mechanics lien that eats into that cap, thereby reducing it, it doesn't change Ivester's obligation to complete the work. It doesn't change the amount that Ivester is ultimately responsible for. And this panel will recall that it is Ivester who agreed to this contractual arrangement with Alliance. If Ivester wants to overpay for rental equipment, it's Ivester's business. The place where it becomes a 93A problem for Mr. Bruno is when someone asks Mr. Bruno to pay more than he would have otherwise paid to have those sites prepared. That has not happened. No one is asking for that.
But Alliance is trying to recover what's owed to it.
Yes.
And why isn't its involvement in this scheme to extract unreasonable rental amounts? How is the Bruno's possible retention of these lots or the $900,000 something that should reduce the damages caused by Alliance's conduct? I understand that Bruno may get a windfall if for some reason Ivester was entitled to that amount and never went after it. but why should that count? I mean, it's a little bit like a collateral source argument, I suppose. Why should Alliance benefit from Ivester not trying to collect that from Bruno?
Well, Alliance isn't benefiting from Ivester not trying to collect from Bruno. Ivester filed its notice of contract before the end of the relationship. In fact, to date and in the record, Ivester was never terminated from this job. For all the record knows, Mr. Ivester will come back once these houses are built and put in the curbs and do the final paving. I tend to doubt it, given the years of litigation that have passed, but that option exists. If a property owner wants to avoid that result, the property owner should terminate their general contractor for cause if they're running late, they're doing a bad job, whatever the property owner's problem is, which changes the amount due or to become due to zero when there is a termination for cause. That's Bloom South Flooring, the YMCA case. So a property owner has the ability to protect themselves, as does a contractor by, say, paying their bills. If Alliance has a mechanics lien right for $585, as this court has found, it is entitled to be paid that by the property owner unless that amount exceeds the amount the property owner owned to the party they were in privity with. It does not. And so reducing that amount to essentially get back to Judge Wilkins's original determination of $180,000 as the fair market value of the use upended the results of the last appeal to this
And your
court.
best authority for that argument, apart from the statute?
For which argument?
The argument you just made.
Argument I just made would be in the Bloom South case for the measure of damages on a mechanics lien and the ability to truncate those damages by terminating your contractor.
We're about to run out of time, so I should ask our panel chief if we
Oh,
can
go
have
ahead.
some more time. So I have another question on post-judgment interest, but I just want to make sure Justice Sachs doesn't have a question first on this issue.
Yeah, I just quickly, you're making a couple of arguments as to why the 93A damages should not include, should be reduced essentially by the lots or the 900,000, and also whatever work Ivester did outside of the contract on individual lots. Were those arguments that could have been made at the original trial where, again, Bruno was requesting 93A damages and was ultimately awarded 93A damages? I mean, if your argument were right, he should have gotten nothing in 93A damages at the first trial because of these two
He did.
offsetting issues.
He got his attorney's fees, but Judge Wilkins...
Right, but I'm saying if your argument were correct, he should have gotten nothing at the first trial.
Well, there is in fact a scheme. It's been found to be knowing and willful, and as Judge Wilkins pointed out, that has caused the litigation over what were originally 4 notices of contracts and liens and dragged through the machinations of the legal process, the appeal, all of which has been compensated with attorney's fees, and we're not arguing about that as a credit against the lien and the damage suffered by Mr. Bruno, but the other $405,000 that the trial court tacked on remand simply wasn't an injury to Mr. Bruno. He got what he expected for less than the price he expected to pay for it. And on post-judgment interest, I would just refer this
Let me ask you 2 questions on that. The first question is, actually, I'm just curious, do you happen to know the approximate delta between post-judgment interest starting with the original judgment versus the amended judgment? What's the ballpark?
$210,600.
And what is your best case that it should run from the original judgment?
Frank v. Fowler allows post-judgment interest back to the date of an original award. That was on a motion award for 231-6F. But I think more importantly is the Haddad v. Walmart Stores case, where you had a jury verdict that got knocked out by the trial court judge. So when the matter was appealed, the trial court outcome was 0. That was reversed by the appeals court, and the jury verdict reinstated, which took it from a low number to a higher number, and post-judgment interest was run back to the date the original judgment should have entered. When the Superior Court addressed this in 2009, I give you the Westlaw site, but it's not a reported case. What the Superior Court held was that calculating post-judgment interest from any subsequent date, such as the date of the amended judgment or the date of judgment after rescript, unfairly prejudices the plaintiff, who is entitled to post-judgment interest from the date on which a correct judgment should have entered. That's the same principle that we're looking to have applied here. Thank you.
Thank you.
Any further? No, all set, all set. Thank you very much.
Good afternoon, Your Honors. May it please the Court, Chris Haberstadt on behalf of Michael Bruno and the involved surety in this matter. Let's first start with jurisdiction and this new theory that was raised today for the first time in court. And our brief makes clear why this court, with all due respect, lacks jurisdiction. There are a number of cases out there.
Do we lack jurisdiction? It seems to me that the cases that say we lack jurisdiction involve a statutory time limit, and in which case we can't exercise our discretion to decide the case. I think your case involves the application of a rule, in which case we can exercise our discretion.
I think this court, the court can entertain the argument, but in the end, the court lacks jurisdiction is what I'm getting at.
Can't if we lack jurisdiction.
Well,
See,
then I think the court lacks jurisdiction because, for the reasons set forth in the brief, under the rules of appellate procedure, they're clear. You have 30 days to file a notice of appeal with the court to perfect your appeal.
From the final judgment.
From the final judgment.
And how was the judgment in your favor on October 7th or 9th or whatever it was, final, when the claims, Alliance's claims had not been reduced to a judgment yet?
Our claims were final because, one, they entered as to the specific claims, the Chapter 93.
But there was no 54B certification or
It was not, Your Honor.
determination. Okay. So sure, it's, final as far as what Bruno is entitled to, but it's not, doesn't wrap up all the claims. I mean, would a notice of appeal have lied from that first judgment in Bruno's favor, or didn't you have to wait?
I believe it did. I believe it did. That judgment entered. That judgment had to do with the remand of this court as to the 93A claims. The other judgment was just the correcting the amount of the mechanics lien that this court had ordered back at the time it remanded the case to the Superior Court for further, so this court was the court that corrected that judgment and sent it back down to the Superior Court and said judgment enters in favor of Alliance in the amount of $585,000 on the lien claims. It is the Bruno judgment that is being appealed from, and that's the judgment, and that's what I submit the period to file an appeal starts. And it should have been filed within 30 days. What I will say is this new theory about the judgment that entered in February of 2024, that judgment entered solely for the purpose of issuing an execution. In this matter, this court had subsequently awarded Mr. Bruno $42,000 in attorney's fees in connection with the first appeal on this matter. When the execution was issued, the court couldn't issue an execution to try to collect that $42,000 without a supplemental judgment as to that claim only, as to this court's award. So to me, that was a ministerial act on the part of the court just so they could issue an execution to include this court's award. It had nothing to do with the merits of the case itself. It had to do with an award of this court. So going back to it, I do believe that the period starts for this appeal on the Bruno claim. At the time judgment on the Bruno claim entered, they failed to file in a timely manner. The motion for reconsideration that was filed outside of the 10-day period permitted under 59E to toll the statute of limitations, and the period never tolled. So I think as to that issue, this court lacks jurisdiction with all due respect because the appeal was not timely perfected.
So let's assume, totally arguendo, we haven't decided anything yet,
Sure.
that the 93A issue is properly before us, not just on reconsideration. What's your argument?
The arguments are a couple of things. This court first sent the matter back down to the Superior Court under a remand order. Under the remand order, the court instructed the trial court to do certain, a rescript order, I'm sorry. Under the rescript order, the trial court was instructed to do certain things. There were no directives on what the court was required to do, other than the court was required to consider the additional damages that get awarded to Mr. Bruno on account of the 93A claim. So the standard here is, as far as whether the remand order is incorrect, is whether whether it conforms with what this court instructed. This court instructed the trial court to do something. The trial court held hearings, had briefing on it, and did something. And it awarded Mr. Bruno the amount which it did, which was the additional $400,000, which compensated for what the court found below was a grossly inflated lien. And that's what the court did here. There was evidence before the court. The trial court, as said in his decision, looked at the underlying pleadings, looked at the findings of fact, looked at this court's order, looked at the evidence before the court, and determined in its discretion that the additional damages under 93A were the $400,000 plus. So this court told the court below to remand. Remand order confirms what this court instructed it to do. There was no error on the part of the trial.
Attorney Travers says, yeah, but you didn't suffer damages, or you didn't suffer loss of money or property within the meaning of 93A. Why do you disagree?
For the reasons set forth in our brief, but I will say this, Your Honor, Justice Neyman, you mentioned one of them. The trial court found that the liens were grossly inflated. The trial court found that the liens should have been $180,000. Based upon what this court did under the mechanics lien statute in Bruno 1, which basically said, trial judge, you can't do what you did, you can't reduce the lien in the manner in which you did because the statute doesn't allow you to do so, it was sent back down. What the trial court did was common sense, basically. The damages are, if Mr. Bruno's lien should have been $180,000, and if the judgment now was $585,000, well, how is Mr. Bruno not harmed if he has to pay that delta? Those are damages that Mr. Bruno has sustained here. So that's the reason, or one of the reasons why damages were found below. The other reasons are set forth in the brief, the years that Mr. Bruno has had to defend this lawsuit on grossly inflated, 70% inflated liens, tying up his properties. So there are damages on the.
But is Bruno getting a windfall because, at least from the current record, he never either transferred the lots or the $900,000 to Ivester?
He's not getting a windfall, but even if he were getting a windfall, so let me take two parts. He's not getting a windfall, but if he were to get a windfall, in other words, if he were to sell these lots, as Your Honor pointed out, why is it that Alliance is the recipient or the beneficiary of whatever windfall that is when this court confirmed or affirmed the trial court's finding that there was 93A conduct here, that this was a scheme. So if there were
in which Ivester was involved, it wasn't just Alliance, right?
Two parties, correct. It takes two.
Right. So if Ivester was involved in the 93A scheme to extract more money for Alliance, because after all, Ivester owed Alliance money, or its principal, then why in computing the damages shouldn't we consider what Bruno also owes Ivester?
Bruno owes Ivester nothing. Nothing. There's no finding that Bruno owes Ivester anything. Mr. Bruno.
Or that Bruno expected to pay Ivester $300,000 plus the two lots or the value, but never paid Ivester the second part. So why don't we consider that in looking at the net result of the transaction in terms of damage to Bruno?
Well, the facts don't get us there, but in the underlying action, the facts show that the underlying contract was never undertaken. So there was no expectation as to anything. The expectation was if Ivester performed the contract through, he would get certain things. The trial court found he did not perform the contract all the way through. So there was no expectation on Bruno's part that he was going to get anything. He had to still hire another contractor to go out and redo or do things that Ivester didn't do under the initial contract, costing him some money. Mr. Bruno, as the record reflects, had to post bonds with the city of Reading, or North Reading, $250,000, I believe is what the record reflects, because work was not done under the contract, and the city wanted assurances that Mr. Bruno was going to have to get the work done. So those are damages that are also on the record that are reflected in our briefs. $250,000 right off the top to the city are damages that he paid. So one, he didn't, there's no, he didn't profit off of this, and he certainly didn't profit off of the scheme that was committed by the two parties in trying to extract monies from him. So with respect to damages, there's clearly a record before the trial court that Mr. Bruno suffered 93A damages. The trial court found willful conduct, didn't treble or double the damages. What the trial court did here in connection with the order back down to it is issued a remand order, which is consistent with what this court asked it to do below, and there's nothing in the record to show that work was clearly erroneous.
With respect to post-judgment interest, you don't dispute that that's properly before us on appeal, correct?
I do, that's correct, Your Honor, yes.
Okay, so that's properly before us.
That is properly before you, and yes.
So there's a case, neither party cited, O'Connor versus Medford, 20 Mass Appeals Court, 761. That case seems to state, in part, that where money from a judgment was ascertained or ascertainable in dollar amount, that we revert back to the original judgment, which sounds logical to me. And I'm having, so I guess what I'm asking is, what is your best case that suggests otherwise?
With all due respect, Your Honor, I'm not
You
familiar with
haven't
the
seen
case,
the
and I'm
case.
not
I
familiar with the
understand
context, and maybe I should have. But I think our best case, I think when you look at the series of cases, you look at one definition of judgment in the rule. It's the final act of the trial court in doing something. You look at the cases that were cited in all of our briefs. I think the Peake case is the specific question that Peake addressed was, what do you do in the case where a judgment is affirmed? And in that case, the court found, yes, you go back to whatever the original judgment was.
Right, but what do you do when the appellate court says, this is the clear answer, this is what your judgment should have been? Why should his client be punished for the mistake of the trial judge?
I don't think he's being punished. I think that the converse is, why should Mr. Bruno be punished by taking a judgment that was $180,000 back at the time, and years later when the appeal that they brought winds up, the court corrected or reversed the judgment and inflated it. I think in a scenario like this, and I don't think there are any cases directly on point on this.
Is Bruno getting his post-judgment interest back to the date that he filed the 93A claim?
No, Your Honor. The quirk here is this. We have prejudgment interest and post-judgment interest. Mr. Bruno is going to get prejudgment interest and post-judgment.
Sorry. So he gets prejudgment interest from the time he filed the 93A claim.
Correct, Your Honor.
And that's going to be on the full amount, if we were to affirm, the full amount of the 93A judgment, not the 180, or not the 101 attorney's fees amount that Judge Wilkins originally ordered, but including the subsequent amount
I would submit that he's I'm sorry.
added by Judge Saroof. So you're going to be looking for interest, whether it's pre or post, from the date of filing of the 93A claim on the entire amount that Judge Saroof ordered, if we affirm that. Is that correct?
No, well, indirectly no, because we're entitled to prejudgment interest on the 180 up until the time that the second judgment came in, and then we're entitled to
101,
interest.
isn't it? It's Alliance that was allowed to get the 180. You were allowed the 101 in attorney's fees
110,
as damages.
exactly right. So prejudgment interest runs on that to the point that the court awarded the additional 400, and it's going to run from there going forward. So the quirk here is because we get prejudgment and post-judgment interest, it doesn't really affect us as much. We get prejudgment interest on the 110 until the court's judgment, the amended judgment, or the judgment on remand comes in, and then we get post-judgment interest during that period.
And so you're not claiming you're not claiming interest on the, how much did the Judge Saroof increase the judgment by 450 or something like that?
150-ish.
You're not claiming interest on that back to the date of filing of the 93A
No,
claim?
we're going to get post-judgment interest on that going forward. So it will be pre-judgment interest, I think, through the date that the remand judgment was recorded. We're not getting pre-judgment interest on we get post-judgment from the date that the court entered the Bruno.
Well, if you were to get pre-judgment interest on that $450,000 that Judge Saroof added, back to the date of the filing of the 93A claim, would that kind of take some of the bite out of the post-judgment interest for Ivester?
Look, it certainly will take some of the bite out of it. I think the question is, with all due respect,
I mean,
what is...
isn't it the
Question is,
same?
what does the law compel?
Isn't it
We
the same
understand that,
principle?
obviously.
I guess, isn't it the same principle?
Not really, and I think you need to look at the principle that in the context of Alliance's action, which was a mechanics liens action, the law provides that you are not entitled to pre-judgment interest. The law provides my client is entitled to pre-judgment interest. So if it weren't for the fact that they were not permitted pre-judgment interest at law under the statute, we wouldn't be here on this issue because it would all be the same. So I will rest with this, as far as the cases go, I think the Fowler and the Carolus cases are the ones that I would rely on, which talk about the final act of the court in doing something. Here, the final act of the trial court with respect to the Bruno judgment was going back and entering judgment on the amount that this court instructed the trial court to do.
Okay.
I'll just say well-briefed and well-argued by both parties.
Agreed, thank you. But just before you go, just to be sure we have no follow-up questions. All right.
Thank you, Your Honor.
Thank you very much. It's a very interesting issue, and we appreciate your answering all of our questions, and we'll take the case under advisement. And
Nice
thank you
to see you both again. Hope this is the last time.
Oh, we're off the record. I was going to say, can I say something? Are we off the record?
No.
Okay, I won't then. Thank you, Your Honors.